My name is Dennis Davis. I'm the Judge President of the Competition Court of South Africa, Appeal Court of South Africa. What that means, just for those who don't know our country, we have a system, three-toed system. We have a competition commission which investigates all sorts of anti-competitive behaviour. If there is a dispute, that goes to the competition tribunal, which if you wish is the court of first instance, and then people want to appeal that, they can finally get to us, the Competition Appeal Court, which is a specialist appeal court dealing with competition cases. What I spoke about today and what my presentation is about is how does competition law work when you look at it through the eyes of a judge or an adjudicator. Let me explain. If you look at a traditional book on competition law, if you listen to traditional competition lawyers and economists, they will tell you that competition law is there to promote consumer welfare, and effectively what that means in the traditional sense of the word is any transaction which is likely to increase prices or diminish output has at the very least an anti-competitive aspect to it which needs to be investigated. Of course, that's easier said than done, but what becomes even more complicated is that in many countries, particularly developing countries, particularly a country like my own, South Africa, our objectives are broader. Our objectives, if you look at the South African Competition Act, is not just to deal with output and price, but also to look at a competitive process which is inclusive. What I mean by that is an economy that actually works for, in our case, 50 million people rather than a few people. That means that any abuse of market power to perpetuate this form of economy at the expense of a more inclusive economy is the province of competition authority. That's essentially the key objective that we have in mind. Now, what that essentially means again is that we work from a premise that markets don't work themselves pure. There's a paradox here. If you look at competition law, it believes in the market. It believes that ultimately markets should work to the advantage of the citizens. But at the same time, it also accepts that markets don't always work, that people abuse power, that power is used to advantage some who have it at the expense of those who don't. And so competition policy and competition law and competition regulation has to look at that broader set of consequences. And that's based, I think, on this assumption that rules of law which shape markets don't just arrive, they don't suddenly descend on the world in some massively unique way. They are constructions which reflect a political framework at a time. And they're choices. And the choices we want to make are choices that empower and open possibilities rather than close possibilities for a few people. And so that's essentially the broad framework. Now that's an extremely difficult challenge to meet. Why? Because you see, if you look at competition law from the point of view of just simply saying, well, let's get some economic evidence which shows us that output has gone down or that price has gone up, that's relatively easy for a court or a tribunal to deal with. When you start balancing a whole lot of other considerations, when you have to look at, for example, does the affected transaction affect unemployment, small businesses, a range of economic interests beyond output and price, then it becomes a lot more difficult for an adjudicator to actually work that out. Let me explain. I know that in Malaysia you don't have merger control. I should say that's a very odd thing for a competition lawyer like myself, because it doesn't seem to me that you can have a proper competition regulatory authority without dealing with mergers. Why? Because mergers are where, in a sense, concentrations grow and are developed, particularly in the global world, where more and more multinational corporations are acquiring and building up their economic power. So let me give you this example from the South African case. We do have merger control, and I'm pleased we do. And our merger control traditionally, again, would say, does the merger is the merger going to substantially lessen or prevent competition from occurring? That's a predictive calculation. So Walmart, the large multinational supermarketeer, decides it wishes to actually have a market in Africa, and it therefore requires 51% of a company called Massmart in South Africa. And what occurs is that, on one level you'd say, because it's got to be a merger that has to be assessed by the competition authorities, why should you not allow it? Walmart brag, probably with justification, their prices are low. Walmart are going to add to the supermarket market in South Africa, and probably in Africa. As a result, there will be more choice. To give a more simple example, somebody comes along, poor person, and they need to buy, let's say, a white shirt for their child to go to school. Now, assuming that the shirt at the other supermarket stores costs 10, and Walmart sells for 7, what you've effectively done is given that person an increase in their wages of 3. So why not accept it? You would. But now comes the point. Walmart provide those cheaper goods and services on 2 bases. Number one, they're not very friendly to their workers. There are senses where they're not prepared to recognize trade unions and collective agreements. And secondly, they use global value chains. That means they will source their products from all over the world in circumstances where the products can be found to be cheaper. That means that the other supermarketeers are now going to have to respond to that. That means that small and medium suppliers to the other supermarketeers in South Africa are going to be out of jobs, out of business. If they are, that's a loss of jobs. At the same time, employment conditions, in fact, deteriorate. Take that all into account. Now, our Act says we've got to worry about small and medium-sized businesses, we've got to worry about employment, and we've got to worry about output and price. How do you balance these issues? How do you decide that the advantage that somebody who gets a cheaper product is 8 rather than 10, that advantage is greater than the disadvantage of unemployment caused by an erosion of small business or by an eradication of the trade union agreements that have taken place? But that's the challenge that we face. Now, those challenges are replicated in other areas. Take abuse of dominance. I understand that there's a great deal of emphasis in this part of the world on abuse of dominance. And I should say that abuse of dominance is no substitute for merger control. However, if you take large corporations who perpetuate their bigness simply by being big, rather than just actually doing it by way of quality of product, then the question arises, how do you deal with them? And there are important questions. Perhaps the most single important question which now arises is the issue of intellectual property. What that means is that essentially, when you've got companies like pharmaceutical companies that own intellectual property, they can extract a far higher price for their medicines than otherwise would be the case, because they're the only ones that own the intellectual property right, and they can squeeze the profits out of markets in fashions that would not be fair. So, in an abusive dominance doctrine, you have a thing called the essential facility principle. So, and this happened in South Africa. We had a situation, tragically, of a massive HIV/AIDS epidemic. The result, which was you needed antiretroviral drugs to help people survive. The pharmaceutical companies were charging huge prices, and they controlled the intellectual property. The question, therefore, arose as to whether you could have generic drugs at far cheaper price. The pharmaceutical companies refused. A non-governmental organization challenges the pharmaceutical companies, invoking the essential facility doctrine, saying, because there's an essential facility doctrine here, you have to allow people generic medicines to be produced, because without your, as it were, protocol, they can't do so. So the essential facility doctrine actually therefore allows the generics to be produced at the expense of the ordinary medicine, reducing the price and adding to the health and welfare of the country. The case was settled, but the essential facility doctrine actually was, I think, one of the reasons why it was settled. So you can see that again with abuse of dominance, those issues are then particularly important as the broader concerns of competition law. In short, what I'm really suggesting is this. In the developed world, competition law concerns output and price. In the developing world, we should be much more concerned about the question of how we have a legitimate, competitive market, and we should also be concerned to a considerable extent about inequality. You cannot have a legitimate market system anymore in the world without dealing with questions of inequality. There is no single bigger item on the agenda now than the fact that the economy is not working for the advantage of citizens, but the economy only works for the advantage of a few. And therefore competition law is being drawn more and more into this particular issue as to how, in fact, it can respond to the modern dilemma of an economy which is perpetuating extraordinary levels of inequality. Why does competition law matter in this regard? Because the whole issue of inequality turns on who captures the rents from the production of goods and services, and the extent to which you can deal with the problem of power, economic power, which allows A to capture the rents at the expense of B, has surely been part of competition law. So what I was trying to suggest in my contribution to this conference, and I should add I'm extremely grateful to be here, it's a great honor to be here, was this, that in the traditional fashion in which a judge or an adjudicator deals with competition questions, the balancing exercises were relatively quite easy, because you had to simply deal with whether in fact the transaction in question or the structure that you're dealing with increased prices or reduced output. Now, by contrast, if you follow my argument, there is a greater and more pressing set of needs for competition law to deal with more complicated questions, to worry about issues of small and medium-sized businesses and how they integrate into the economy, to worry about the fact of how, if you don't allow this transaction or that transaction, it may affect particular communities in certain areas, to worry about the fact that what you get is a diminution of welfare because you simply are reducing employment because you're weakening your own local businesses. And all of that within the context of the global structure. And even more important than that, you have to worry how it is that transactions of multinational corporations can capture the rents in a country and do so to the advantage of people in the developed world and to the disadvantage of people in the developing world. And these now become the issues of competition law. And that then means that we've got to start training our adjudicators to, as it were, be concerned with what we call polycentric consequences. That means not just simply being able to say, I only deal with something when I know that there's one consequence, but rather to look at how the adjudicator is going to deal with a problem where you've got to balance a whole range of issues. And then finally, we should not get into the laissez-faire approach, where you're only worried about what we call type 2 errors. That is, that the only areas that we're worried about is under-regulation, and that we are so concerned that we don't over-regulate, that we allow all sorts of anti-competitive activity in for fear that in fact we mess with the market. Markets have to be taken not to work themselves pure. And as a result of that, we therefore are going to inevitably involve ourselves as competition authorities with a complex range of decision making which go way beyond narrow conceptions of efficiency. My point is simply this, that if you believe in the idea of a market that works for everyone, that market has to have legitimacy. It cannot allow certain sectors of the economy to subvert the market for their own purposes and to capture the rents for themselves to the detriment of everyone else. That means a more ambitious conception of competition law, and in turn, that means greater burdens placed on competition authorities such as your one in Malaysia or my one in South Africa.